आपण YouTube लाईव्ह स्ट्रीमिंग सुरू केलंय. हनी?
Yes, sir. Yes.
आपको नेटवर्क नहीं है सही तरीके से, वो चेक करो, आवाज ब्रेक हो रही है.
Just a second.
We will start now.
Yes, sir.
Yeah. First, I welcome Advocate Dr. Rajendra Anbhule sir on behalf of Local Education Society, NB Thakur Law College, and this initiative is taken under work from home policy. As in the situation like pandemic, nationwide lockdown, we are unable to conduct classroom teaching. Therefore, the thought strike in my mind that why should not eminent personalities, those who are always ready to share their knowledge with students' fraternity and young advocates. Therefore, I request Advocate Dr. Rajendra Anbhule sir to speak on practical subject so that there will be a value added knowledge to the students and law students and young. I request Advocate Hani Narayani to introduce Advocate Dr. Rajendra Anbhule sir.
Thank you, sir. Sir, it is an immense pleasure and a true honor for me to introduce our esteemed speaker for today. Foremost, I would like to thank you, sir. Our audience may be unaware of this fact, but we owe a special thanks to you for being here with us today. It is also a very difficult task for me to introduce a man who needs no introduction, but I cannot avoid the temptation of speaking about you, sir. Advocate Rajendra Anbhule sir has completed PhD in law in the year 2013. He stood first in LLM with a gold medalist from Pune University. He has also completed MA in political science from University of Pune. He is an Supreme Court advocate on record in Supreme Court of India, practicing advocate in Supreme Court and High Court of Bombay. He is advocate of Savitribai Phule University, Indian Institute of Science and Education and Research, Pune, etc. He has handled all the kinds of cases pertaining to constitutional laws, civil laws, criminal laws, land laws, labor laws, trust law, personal law, commercial law, service law, education and arbitration, etc. He is Honorary Director of Center of Advanced Legal Studies, Training and Research. He is also member of Board of Studies in Faculty of Law, Bharati Vidyapeeth, Pune. He has written several books on various law subjects and acted as a resource person for Bar Council of Maharashtra and Goa, State Women Commission, Police Training Center, and other respected institutions. He is amongst us today to speak about the topic domestic violence law, practice, procedures, and judicial views. Please welcome the crowning jewel of legal field, Advocate Dr. Rajendra Anbhule sir. Over to you, sir.
Thank you very much. Am I audible?
Yes, sir.
Yes.
Welcome to all of you to this virtual world, wherein the method of seminar has been replaced by new method of webinar, because of which we got an opportunity to exchange our thoughts in relation to some recent topics. days are not far wherein not only the oral hearing in future will be conducted by video conferencing, but even the examination in chief and cross will also be part of that. So, as a lawyer, we have to adopt this new method of technology if we want to survive in legal profession. It is said that society changes faster than law. So law has to keep pace with changing need of the society. In India, judiciary has responded positively to the needs of the society, but the legislature has been proved dormant. There are several examples of it. As you must be aware that Vishaka versus State of Rajasthan was decided by Supreme Court of India in 1997. Legislation was passed in 2013 after the gap of 16 years. In 1991, right to education was declared by Apex Court as a fundamental right in Mohini Jain versus State of Karnataka. Mohini Jain was partly overruled in 1993 when Unni Krishnan versus State of Andhra Pradesh was decided, wherein Supreme Court of India held that right to education is a fundamental right, but from the age of 6 to 14. And above that, right to education depends upon economic capacity of the state. By 86th Amendment 2002, Article 21A was inserted in Part 3rd of the Constitution, wherein right to education was declared as a fundamental right. But legislation came to be passed in 2009. Third, in 1989, Child Right Convention was ratified by United Nations. Juvenile Justice Care and Protection Act came to be passed in 2000 after the gap of 11 years. And so far as today's topic is concerned, Convention on Elimination of All Kind of Discrimination Against Women was ratified by United Nations in 1979. The Protection of Women from Domestic Violence Act was enacted in 2005, that is after the gap of 26 years. Though delayed, this law has been proved beneficial as compared to all other laws which were there enacted by Parliament of India for the protection of women. In today's discussion, I will take cursory glance of statutory provisions which are there for the purpose of the Act, and at the same time for the purpose of understanding the practice and procedure which is there in India in relation to this particular Act. So I have framed some issues in relation to this particular topic, which are a practical one. Number one, Act is enacted in 2005. What is the nature of this Act? Whether it is civil or whether it is criminal. Statement, object and reason of the Act is saying that this law has been enacted with a view to provide effective civil remedy to the aggrieved person. But at the same time, if you read section 28 of the Act, it says that magistrate has to lay down the procedure as prescribed by Code of Criminal Procedure 1973. So the first issue is, what is the nature of the Act? Whether this law is civil or whether it is criminal. Number two, whether the Act of 2005 is retrospective in nature. If any act prior to of this act, then whether that act can be brought within the purview of this particular legislation, and whether remedy can be sought under section 12 of the act. Third question is very close to my first issue, whether limitation is applicable to the Act of 2005 if any application is to be filed by aggrieved person under section 12 of the Act. As I said earlier, the statement, object and reason is saying that this is a civil law enacted for benefit of aggrieved person, but section 28 is saying about the procedure which is to be as per CRPC. So the issue is, third issue is, whether section 468 of CRPC is applicable to the proceedings which are initiated under section 12 of the Act of 2005. Fourth issue is there, that is, after filing of application under section 12 of the Act, whether amendment is permissible. Number 5, what is the status of live-in relationship under the Act of 2005, whether live-in relationship is recognized by this particular law. Issue number 6 is, if maintenance is granted to wife under section 24 of the Hindu Marriage Act, or under the provision of Hindu Adoption and Maintenance Act, or under the provision of section 125 of CRPC, after that, whether that aggrieved person is entitled to claim maintenance again under section 20 of the Act of 2005. In simple words, whether multiple maintenance can be claimed. Next issue is, if you are practicing in the court, this law speaks about filing of domestic incident report by protection officer or service provider. And section 12 of the Act is saying that at the time of disposing an application filed under section 12, magistrate has to consider domestic incident report filed by protection officer. So the issue is, if the report is not filed by protection officer, then whether that report is mandatory, whether that report affects the merit of the case, and in absence of that report, whether magistrate can decide an application filed under section 12. That is also one of the issues which I am going to discuss. Another issue is there, after the death of husband, whether a widow can claim maintenance from in-laws or brother-in-law under section 12 of the Act. Again, in any maintenance proceeding, normally lump sum maintenance is granted at the time of final hearing. Again, I have raised the issue in relation to today's discussion that whether lump sum maintenance can be claimed in interim proceeding initiated by aggrieved person under section 23 of the Act. Again, the issue is, even though the Act is enacted for benefit of women, whether male can claim relief under this particular Act. And the last issue which I'm going to discuss is that if an order is passed by magistrate under section 12 or 23 of the Act in relation to maintenance, and if that order is violated by respondent, then by which mode that order is to be executed by the court. Apex Court of India as well as various high courts have tried to settle the law in relation to the Act of 2005. With a view to understand judicial views in relation to the Act of 2005, the practice and procedure in this particular Act, we have to discuss some basic provisions which are there in the Act of 2005. But prior to that, as we are discussing the Act of 2005, I am bound to discuss background of this particular act, which is very much important to understand the subsequent development in relation to practice and procedure. Background of this act can be classified in three categories. First will be international background. Second will be section 498A of Indian Penal Code, which was inserted in code in 1983 amendment. And third is constitutional provisions in relation to Article 14, Article 15, Clause 3, and Article 21 of the Constitution. Now coming to first aspect, international provisions. You are aware that United Nations was established in 1945. Universal Declaration of Human Rights was the first declaration which was made by United Nations in 1948, wherein certain basic rights were recognized. International Covenant on Civil and Political Rights was ratified by United Nations in 1966. Even though this is so, UDHR of 1948 or Covenant of 1966 did not made any provision for protection of women from domestic violence. For first time in the history of human rights, in 1979, when CEDAW was ratified by United Nations, that is Convention on Elimination of All Forms of Discrimination Against Women, for the first time, domestic violence was acknowledged as a human right issue. Again, by Vienna Declaration of 1993, and again in Beijing Declaration and Platform for Action of 1995, violence was recognized as a human right issue. So there were three documents. First was CEDAW, second was Vienna Declaration, and third was Beijing Declaration, wherein domestic violence in family was recognized as a human right issue, and all the state parties were directed to take steps with a view to ameliorate the position of women. And as India was a state party, in India, this act was enacted in 2005. Second issue is in relation to section 498A of Indian Penal Code. Prior to 2005 in India, there was no effective civil law which will deal the problems of women. Section 498A was inserted in IPC in 1983 by amendment, but this law was not sufficient to provide justice to the woman. So, when the question was of maintenance, when the question was of residence, when the question was of protection, whenever the question was of social security, Section 498A was not able to address this phenomena effectively. Now, presume for some time, that husband and his relatives are prosecuted under section 498A of IPC. They were not discharged under section 239 of the CRPC. Hence, charge was framed under section 240 of the Criminal Procedure Code. After framing of the charge, prosecution opened the case, trial was conducted, guilt was proved beyond reasonable doubt, and husband and in-laws were sent to jail. By sending in-laws and husband to jail, wife is not going to get maintenance, residence, protection, social security, and all the other reliefs which she is in need. That's why prior to 2005, there was no effective civil law which will address this phenomena. That's why the Act of 2005 was enacted. This is the second reason, background for enactment of 2005 Act. Now coming to third important aspect. As we know that Constitution of India came into existence on 26 January 1950. List of fundamental rights is provided in Part 3 of the Constitution. In relation to today's discussion, there are three important articles which were instrumental for enactment of this particular act. First is Article 14, second is Article 15, Clause 3, and third is Article 21. Article 14 says that state shall not deny to any person equality before law and equal protection of law within the territory of India. Article 14 can be divided in two parts. First is equality before law and second is equal protection of laws. Equality before law is a negative concept which we have derived from the writing of Dicey. It's a Diceian concept that right from Prime Minister down to a humblest peasant, everyone is equal before the law. But the concept of equal protection of law is a positive concept, wherein it says that unequal cannot be protected equally. If someone is unequal, equal protection cannot be given to him or to her, and by giving special protection, by making protective discrimination, that particular person can be bring into mainstream of the society. So for that purpose, under the clause equal protection of law, Apex Court had developed doctrine of reasonable classification, which can be discussed in two parts. First, the classification shall be based on some intelligible differentia which distinguish a person or group from others which are left out of the group. And second is the differentia must have some rational relation to the object sought to be achieved by the act. What reasonable classification doctrine specifies is that there must be nexus, connection, relationship, association between basis of the classification and object of the classification sought to be achieved by the act. So, woman who is a sufferer of domestic violence was the basis of the classification, and object was to bring her into mainstream of the society. So Domestic Violence Act satisfy the test of reasonable classification. But you must be aware that reasonable classification was rejected by Supreme Court of India itself in 1974 when Royappa versus State of Tamil Nadu was decided, wherein Supreme Court of India held that even though the classification is reasonable, but if it is arbitrary, then it can be set aside. So it was a new concept of equality which was evolved by Supreme Court of India in Royappa case, which was again followed by Apex Court in Menaka Gandhi versus Union of India in 1978, as well as in Ajay Hassia versus Khalid Mujib of 1981. In 1996, in state of Andhra Pradesh versus McDowell, Apex Court rejected doctrine of arbitrariness. and it was held by apex court in McDowell case that even though a statute is arbitrary, it cannot be challenged under Article 14 of the Constitution. But you must be aware that the McDowell judgment of 1996 was overruled by Supreme Court of India in 2017 when Saira Bano versus Union of India was decided. And in Saira Bano case, Supreme Court of India invented new doctrine, that is doctrine of manifest arbitrariness, wherein Section 2 of Muslim Personal Law Application Act 1937 was struck down by Supreme Court of India because it violated Article 14 of the Constitution. And doctrine of manifest arbitrariness says that any statutory provision, which 2017 itself, Putta Swamy versus Union of India was decided by Supreme Court of India, wherein Supreme Court of India held that right to privacy is a fundamental right under Article 21 of the Constitution. Manifest arbitrariness, apex court struck down Section 397 of the Indian Penal Code as unconstitutional. Offense of adultery. When Joseph Shine was decided, two important law points were discussed by Supreme Court of India. Not only Section 497 of the Indian Penal Code, even Section 198, Clause 2 of CRPC was also struck down by Supreme Court as unconstitutional. And two important law points were discussed by Supreme Court of India. The first was Section 497 was considering wife as a property of the husband. That cannot be so when the human right has been evolved to such a greater extent. And second was that Section 497 did not permit wife to have a sexual choice. And when Putta Swamy was decided by Supreme Court of India in 2017, wherein right to privacy was declared as a fundamental right, in Joseph Shine case, Supreme Court of India clarified that there may be sex beyond marriage. Now, so far as Domestic Violence Act is concerned, as I stated earlier, that society changes faster than law. In India, Supreme Court of India has positively responded to that, but legislature has been proved dormant. Now, in 2019, when Joseph Shine was decided, Supreme Court of India has clarified that there may be sex beyond marriage. But the issue is, if a wife is having relationship with any outsider, with her friend, then whether husband is liable to pay the maintenance? Another question is, out of that relationship, if she got conceived, then who will take responsibility of that child? Whether that friend or husband. Now, legislature has to address this new phenomena which has been evolved by Supreme Court of India in Joseph Shine case. Now, to Article 14, Article 15 Clause 3 is there, which is a genesis of Act of 2005, which says, Article 15 Clause 3, that nothing can prevent the state from making any special provision for women and children. So, state is empowered to enact a special law for women and children, and the Act of 2005 is classic example of that. And coming to last article which is there in relation to today's discussion, that is Article 21, which says that no person shall be deprived of his life and personal liberty except according to the procedure established by law. You are aware that Gopalan versus State of Madras, decided by Supreme Court of India in 1950, was overruled by Supreme Court of India in 1978, when Menaka was decided. In the wake of Menaka, the scope and ambit of Article 21 has been widened, wherein Supreme Court has clarified in category of cases that right to live does not mean mere animal existence, but it means right to live with human dignity. And the present settled position of law is not only a male person, but even female is also entitled to equal rights. And when prior to that, Indira Nehru Gandhi versus Raj Narayan was decided by Supreme Court of India in 1975, wherein Supreme Court of India held that equal justice is basic structure of the Constitution and equal rights are applicable to everybody. So, as a background, there were three reasons for enacting first was internal section 490. Third was constitutional provisions in relation to Article 14, 15, Clause 3, and Article 21. Now, before discussing practice and procedure in relation to this particular act, let me take cursory glance of the Act of 2005, and then we'll move to the practical part of today's discussion. There are 37 sections in the Act of 2005. The first section deals with title. I will not waste more time in statutory provisions, but still for the purpose of understanding, we have to discuss that. Section 2 deals with definitions, wherein 4 definitions are important. That is, aggrieved person under Section 2A, domestic relationship under Section 2F, share household under Section 2S, and respondent under Section 2Q, which has been struck down by Supreme Court of India in 2017 in Hiralal Harsora case. Now coming to first Section 2A. Section 2A says that aggrieved person means any woman who is having domestic relationship with the respondent and who allege that violence is committed against her by respondent. Section 2F says that domestic relationship is that relationship wherein aggrieved person has resided with respondent in a shared household at any point of time, and they are related by consanguinity, by marriage, by relationship in the nature of marriage, by adoption, or as a part of joint family. So 5 aspects are recognized by Section 2F while defining domestic relationship, that is consanguinity, marriage, relationship in the nature of marriage, adoption, and even joint family. Coming to Section 2S, Section 2S says that shared household is that household wherein aggrieved person has resided with respondent at any point of time in domestic relationship, whether the house is own house, whether it is a tenanted house, or whether it is a house of joint family. So 3 properties are recognized by Section 2S as a shared household, in which first is own house by the parties, second is tenanted house, and third is joint family house. Now coming to fourth aspect, Section 2Q, definition of respondent. And Section 2Q says that respondent means any adult male person who is in domestic relationship with the aggrieved person and against whom aggrieved person has claimed remedy by filing a complaint, provided that a aggrieved wife or female having relationship in the nature of marriage is also entitled to file complaint against husband or male partner and their relatives. After this definition, coming to Section 3, definition of domestic violence is given, wherein domestic violence cannot be only an act, but it may be even a omission, commission, or conduct of respondent. So domestic violence may be an act, it may be a omission, it may be a commission, or it may be a conduct of respondent. And Section 3 of the Act has classified domestic violence in 7 categories. It may be physical violence, mental violence, verbal violence, it may be even a emotional violence, it may be even a sexual violence, it may be a economic violence, or it may be even a demand of dowry. And section 3 further says that while deciding a case under Domestic Violence Act, the overall fact and circumstances of the case are to be taken into consideration by the magistrate. This is very important. The overall fact and circumstances of the case are to be considered by the court. Now coming to section 4, it's an academic one wherein it is the duty of a person where violence is committed to inform that to protection officer, so that protection officer can initiate action under this act. Section 5 is very important because it discusses about duties of magistrate and police officer, wherein 5 duties are there. First, they should inform aggrieved person about the right which are available under this act. Second, they should also inform her about the remedies which can be claimed. Thirdly, they should inform about the service of protection officer which is available. Fourthly, they should inform about the service of service provider which is available. And fifthly, very importantly, they should also inform that lady about the legal aid which can be provided to her under the Legal Services Authority Act of 1987. And section 5 further says that after getting information, if the police officer came to know that the respondent has committed an offense under section 498A of the IPC, then he has to register the FIR. So friends, very importantly, so far as Act of 2005 is concerned, not only the proceeding under section 12 can be filed against respondent, but at the same time, parallel proceeding under section 498A can also be filed. So this particular law not only deals with promoting a proceeding under section 12, it also even helped that aggrieved person to file proceeding under section 498A for same cause of action, civil and criminal, both proceeding can be initiated. It is permissible. Section 6 speaks about duties of shelter home. If aggrieved person is evicted from a share household, then she can be kept there. Section 7 speaks about duties of medical facilities or medical officers, wherein she can be given medical assistance. Section 8 and 9 deals with appointment of protection officer and functions of protection officer. Protection officer can be appointed by government of state under section 8, and under section 9 he is having some powers and functions right from the information of domestic violence till the eradication of that violence or till the execution of order of the court. Protection officer has to work under the provision of this act. Section 10 speaks about service provider who may be recognized by state government, that is Women and Child Development Department under section 10 of the act. And section 11 deals with duties of government. What are the duties of government? All the stakeholders are to be sensitized by the government. Periodic sensitization should be given to them. Awareness training should be conducted to them so that this act will be implemented effectively. After this, most important part of the act is there in relation to practice and procedure, that is section 12 of the act. Application can be filed in the court of magistrate under section 12 of the act, 12 clause 1. That application can be filed by wife, by aggrieved person, or by any other person on her behalf, or even by protection officer. Section 12 further says that the application which is to be filed by aggrieved person under section 12 of the act shall be as per form number 2, which is there in the schedule. Section 12 further says, when the matter is filed under section 12, magistrate shall fix first date of hearing within 3 days of the filing. And after first hearing of the matter, magistrate shall dispose that application within 60 days. That is a provision which has been discussed under section 12 of the act. After section 12, section 13 is there, which deals with issuance of notice to respondent. So notice can be issued to respondent under section 13. Respondent can appear in the court of law, and when he appeared before the court, magistrate can conduct counseling under section 14 of the act. If the counseling is successful, matter may be disposed. If it is not successful, then trial will proceed. So section 15 is there, wherein magistrate can take assistance of any particular person who is a welfare expert. If required, under section 16, magistrate can conduct in-camera proceeding. And according to section 17, right to residence has been recognized, wherein it has been provided that this right cannot be taken away except by the way of due procedure of law. Friends, after this, section 18 to 22 is there, which deals with some remedies, some reliefs, which can be granted in favor of aggrieved person. And the first relief is protection order under section 18 of the Act. Now, when this order can be passed, this order can be passed when respondent is committing any domestic violence, if he is aiding in the commission of domestic violence, if he is entering the place of employment of the aggrieved person, or if he is communicating with the aggrieved person, which is itself a violence, or when he is alienating the assets of the family. And not only this, when the aggrieved person is having relatives, and if any violence is caused to her dependent, then that is also a domestic violence, wherein protection order can be passed by magistrate under section 18 of the Act. Now coming to another relief, that is residence order, section 19 of the Act. By residence order, magistrate can pass an order not to dispossess the aggrieved person from the house. Number one. Number two, even magistrate can remove respondent from that house. Number three, even magistrate can restrain the respondent from entering in that house. Number four, even magistrate can direct the respondent not to alienate the shared household. And fifthly, even magistrate can also direct the respondent not to renounce his rights which are there in that particular shared household. If court came to know that it is not safe to keep that aggrieved person in shared household, then another remedy is provided by law, that is magistrate can pass even a residence order in form of alternative accommodation, paryayi nivasachi soy. And by passing that particular alternative accommodation order, magistrate can direct respondent to pay the rent of that particular house along with the deposit. Section 19 also deals with recovery of stridhan, wherein application can be filed by aggrieved person. After this, section 20 is there, which deals with monetary relief order. Now, monetary relief order is not limited by section 20 only to the loss of earning of the aggrieved person, or even to the medical damage which has been caused to her, or only to the damage to the property caused to the aggrieved person, or even the maintenance which is granted by magistrate under section 125 of the CRPC. The concept of monetary relief is much wider than that. It goes beyond that. So beyond 125 maintenance, loss of earning, destruction of property, or damage to the property of aggrieved person, monetary relief can be granted for domestic violence caused by respondent to aggrieved person. And section 20 says that relief granted under section 20 shall be consistent with the standard of living to which the aggrieved person is accustomed. It further says that monetary relief may be monthly or it may be even lump sum. Such kind of provision is there in section 20. Now coming to section 21, section 21 deals with custody order of a child. Now, after filing of the case, if custody is with husband, wife can file application for temporary custody of child, and in that case, court can pass the order wherein visitation rights can be given to the respondent. Section 22 is there, which deals with compensation order for mental agony and domestic violence to the aggrieved person. And section 23 deals with interim order, which can be granted by the court. Section 23 clause deals with interim order, and section 23 clause 2 deals with ex parte ad interim order. Ex parte ad interim order can be granted by a court till the disposal of interim application, or it can be granted till the appearance of the respondent in the magistrate court. And this order can be granted when applicant has filed affidavit as per form number 3 of the schedule, which is there under the rules of 2006. So she has to file affidavit as per form number 3 if she want ex parte ad interim relief under the Act of 2005. After that, Section 24 provides for copies which can be given by magistrate to the parties free of cost. And further, Section 25 says, if any order is passed by magistrate and if there are any change circumstances, then that order can be altered, revoked, or modified by magistrate under Section 25 of the Act. So for change circumstances, order can be modified by magistrate. It can be altered by magistrate under Section 25. Section 26 is very important. We says that relief can be granted in other proceeding also. So all the reliefs which are available under Domestic Violence Act from Section 18 to 22 can be granted in any other proceeding which is initiated either by other parties, by respondent or by aggrieved person in any other court of law. So presume for some time that husband has filed proceeding for divorce against wife. In that case of divorce, wife can file application under Section 26 of the Act and she can claim protection order, residence order, or maintenance also. That's why Section 26 is very important, wherein relief can be granted, can be claimed in a proceeding which is pending in any other court. Section 27 deals with jurisdiction of the court, wherein the jurisdiction is there to the parties where they are residing. The jurisdiction is there where the aggrieved person is carrying on business. And thirdly, the jurisdiction is there where the cause of action has arose. So jurisdiction is provided to the magistrate and he can deal with the case which is filed under Section 12 of the Act. Section 28 discusses about procedure, and Section 28 says, while dealing with the application filed under Section 12 of the Act or under Section 23 of the Act, the magistrate shall follow the procedure as laid down under the Code of Criminal Procedure 1973. And Section 28 Clause 2 says that magistrate may also follow the procedure which is his own procedure. It means that magistrate can lay down his own procedure while disposing of an application filed under Section 12 and Section 23 of the Act. In that case, he may ignore even Section 28 Clause 1, that is the CRPC procedure. So inherent jurisdiction is given to magistrate under Section 28 Clause 2 of the Act. Section 29 deals with provision of appeal, wherein it has been provided that appeal is to be filed to the Court of Session within 30 days from the date of order. Again, Section 30 is there, which says that protection officer and service provider is a public servant as per Section 21 of the Indian Penal Code. Section 31 and 32 are very important. We discussed Section 18, which discusses about protection order. If protection order is violated, then it is a punishable offense under Section 31 of the Act. And Section 31 has provided the punishment of 1 year and also 20,000 rupees fine to respondent. And Section 32 says that the offense committed under Section 31 is cognizable and non-bailable. And on the sole testimony of aggrieved person, that court will come to the conclusion that there is a violation of that particular order. 30 the punishment is provided by Section 33, that is even 1 year punishment as well as 20,000 rupees fine. And Section 34 says that before initiating proceedings against protection officer, the sanction of government should be obtained because he is a public servant. Section 35 says if the protection officer has discharged his duties in good faith, then he cannot be held liable for any punishment or proceeding. And Section 36 says that the provisions of this Act are in addition and not in derogation to any other law for the time being in force. And last section is section 37, which says that rules which can be framed under this particular act can be framed by central government. And accordingly, central government had framed the rules in 2006. And in 2006 itself, the Domestic Violence Act of 2005 came into operation. Now coming to last important aspect of today's discussion, that is in relation to practice and procedure and judicial reviews. The first issue is, what is the nature of the proceedings under this act? Whether this act is civil or whether it is criminal. Now, very importantly, this issue of nature of the act has been settled by Honorable Bombay High Court in full bench judgment of Nanda Kishore Vyavare versus Mangla. The judgment was given by Bombay High Court in 2018. It's a full bench judgment in Nanda Kishore Vyavare case, wherein Bombay High Court held that predominantly the Act of 2005 is civil in nature. The proceeding under section 12, under section 23, under section 18, 19, 20, 21 and 22 will be of civil nature. But if breach of protection order is there under section 31 of the Act, and if negligence is there under section 33 of the Act, then the procedure will be criminal in nature. That's why, so far as initiation of proceeding and hearing under this Act is concerned, Bombay High Court full bench held that the proceeding is civil in nature. Coming to second aspect, whether the Act is retrospective in nature. In V.D. Bhanot versus Savita Bhanot, in 2012, Apex Court held that Domestic Violence Act is having retrospective operation. And in this particular case, after 31 years of marriage, at the age of 63, application was filed under section 12 of the Act, which was held by Apex Court as maintainable. Now, if you come to another important judgment of Apex Court, that is Shalini versus Kishore of 2015. In this case, husband and wife were residing separately 15 years prior to the commencement of the Act. From 1995, they were residing separately. Still, Supreme Court of India held that the petition filed under section 12 of the Act is maintainable because the Act is retrospective in nature. So now the issue has been settled now that the Act is retrospective in nature. Now coming to third important aspect, that is doctrine of continuing violence. Doctrine of continuing violence has been evolved by Supreme Court of India in relation to economic abuse. In the case of Saraswati versus Babu of 2014. And in Saraswati versus Babu, Apex Court of India clarified that whenever there is economic abuse, there is continuous violence committed by respondent, in case of which limitation is not applicable. So for every act of negligence, fresh cause of limitation is started against the respondent. So Saraswati versus Babu deals with doctrine of continuing violence. Now, fourth important aspect is there in relation to issue of limitation. Let me clarify. In Inderjit Gherwal versus State of Punjab in 2011, Supreme Court of India observed that CRPC is applicable to Domestic Violence Act and section 468 can be read. But let me clarify that in Inderjit Gherwal case, the issue of limitation was never discussed, or it was never argued before the Apex Court. That's why the judgment of Supreme Court of India in Inderjit Gherwal cannot be treated as a binding precedent because issue of limitation was not argued, or it was even not discussed by the Apex Court. But the issue was in relation to the void marriage. So if we consider Saraswati versus Babu, V.D. Bhanot case, and even Shalini versus Kishore of Apex Court, and Nandakishore Vyavare judgment of full bench of Bombay High Court, the law is now settled that so far as filing of the cases under section 12 of the act is concerned, limitation is not applicable. Very importantly, Shalini versus Kishore is saying that even though wife is residing separately from husband 15 years prior to the commencement of the act, still she is entitled to file application, and doctrine of continuous violence has clarified that maintenance can be claimed anytime and issue of limitation cannot be held applicable. Now, very importantly, fourth important aspect is there, that is now in relation to amendment, whether amendment is permissible under section 12 of the act. And there is a judgment of Apex Court in 2016, that is Kuna Paradi versus Kuna Paradi, wherein Apex Court held that yes, amendment is applicable. Applicant who is aggrieved person can file application for amendment in two circumstances. Number one, if any subsequent event has happened which makes it necessary, and even another important reason is there, that is with a view to avoid multiplicity of proceeding. Amendment is permissible in the application filed under section 12 of the act. Another issue is there, whether quashing is permissible under Domestic Violence Act. Presume for some time that application is filed by wife and it has been transpired in future that there is no case made out by her. Prima facie case is not there. Allegations are very vague. General allegations are there, and the proceeding has been filed with a view to abuse the process of the court. You know, Apex Court has clarified, even High Court has clarified in so many cases that even though applicant has filed application under section 12 of the act, she may not be a victim in all cases. Sometimes it may happen that husband may be a victim. And in Ashish Dikshit versus State of UP in 2013, Supreme Court of India clarified that quashing can be made so far as proceeding under Domestic Violence Act is concerned. That issue is now settled. Now, I told you about the functions of protection officer, wherein it was discussed that protection officer has to file domestic incident report in the court. That domestic incident report has to be filed as per form number 1, which is there in the schedule. Now, the issue is, if no report is filed by protection officer, then whether the order passed by magistrate is legal and valid. Because section 12 is saying, while passing final order, magistrate shall take into consideration the domestic incident report filed by protection officer. But that issue is also settled by Honorable Bombay High Court in 2012, when Manoj Changani versus Prem Changani case was decided, wherein Bombay High Court held that even though domestic incident report is not there on record at the time of final order, which is to be passed by the magistrate, it will not affect the merit of the case. And in absence of DIR report, magistrate can pass the order, which is final one. But if the report is there on record, then it is to be considered by the magistrate. So, so far as DIR report is concerned, that issue has now also been settled. Now, the issue is whether one female can file a petition against another female under this particular act, because the title is Protection of Women from Domestic Violence Act, whether female can be a respondent. In 2011, in Sandhya Wankhede versus Manoj Wankhede case, again Apex Court of India clarified that one female can file case against another female, and legislature never intended to exclude a female from the category of respondent so far as section 2 key of the act is concerned, and even relatives includes female relatives of the husband also. That was the judgment of Sandhya Wankhede case. And in 2017, in Hiralal Harsora versus Kusum, Supreme Court of India struck down section 2Q of the act as unconstitutional. The word adult male person stands to be deleted, because it was the argument of the petitioner that the Domestic Violence Act of 2005 is not gender bias. It is a gender neutral law. And as it is a gender neutral law, very importantly, in all cases, even respondent cannot be a male, respondent may be a female. So the provisions of section 2Q, which we are discussing about adult male person, came to be deleted because of the judgment of Harsora case in 2017. And Supreme Court of India further clarified that after deleting the word by applying the doctrine of severability, the word adult male person, if the remaining words which are there in that particular definition are useless, the entire definition is to be struck down. And in Harsora case, Apex Court did that in 2017. Now, another important burning issue is there in relation to live-in relationship. The issue is whether live-in relationship is recognized by the Act of 2015. Very importantly, one judgment was decided by Justice Karju when he was the judge of Allahabad High Court. Payal Sharma versus Nari Niketan, wherein the issue was whether a lady who is major can reside with her boyfriend in a flat without marriage, and whether it is illegal one. Writ of habeas corpus was filed in Madhya Pradesh, in Allahabad High Court, wherein Justice Karju clarified that a lady who is major residing with a boyfriend in a flat is not doing anything which is illegal. It may be regarded by society as immoral, but it is not illegal. And morality cannot be enforced unless it is supported by law. Morality cannot be enforced unless it is backed by law, unless it is part of the law. So, even though Payal Sharma is not a judgment in relation to domestic violence, there was a history in relation to right to privacy, wherein not only the high courts but even the apex court has tried to settle the law by saying that it is protected under Article 21. Finally, in 2017, right to privacy in the light of Puttaswamy case is a fundamental right under Article 21. But in relation to the Act of 2005, one landmark judgment has been given by Apex Court in 2010, that is Velusamy versus Petchiamal. And in Velusamy case, Apex Court of India held that without marriage, if any lady is residing with her boyfriend, with her male partner, she is entitled to invoke the provisions of the Act of 2005, but for that purpose, 4 conditions are to be satisfied. The first condition was both must be major. Second, both must be unmarried. Third, both must have resided in a shared household at any point of time. And fourth was society must treat them as a spouse. If these 4 conditions are satisfied, then a female who is having relationship in the nature of marriage is entitled to file complaint against her male partner as well as his relatives. Subsequent to Velusamy judgment in 2013, Apex Court decided Indra Sharma case. In Indra Sharma case, the female was aware that the male partner with whom she is having relationship is a married person. And as the criteria of Velusamy was not satisfied, Apex Court did not regard her as an aggrieved person under Section 12 of the Act. So, all relationships cannot be treated as relationship in the nature of marriage is a settled law discussed by Apex Court in Velusamy case. Now, another important aspect is there. Presume for some time that the marriage is not valid. Application was filed under Section 125 of the CRPC and the same came to be rejected by the magistrate. The issue is, after dismissal of application under Section 125 of the CRPC, whether that lady can file application under Section 20 of the Domestic Violence Act claiming maintenance. Apex Court has decided one case in 2019, last year, Lalita Topo versus State of Jharkhand, wherein Apex Court has held that even though a lady is not legally wedded wife, and even her application is rejected by magistrate under Section 125 of the CRPC, she is entitled to file proceeding under Section 12 of the Act and she can claim maintenance under Section 20 of the Act. So Lalita Topo of Apex Court is a classic example that denial of maintenance under 125 is not a bar to claim maintenance under Section 20 of the Act. Another important aspect is there. Now the issue is, if maintenance is granted under 120 of CRPC, 125 of CRPC, or Section 24 of Hindu Marriage Act, or under the Hindu Adoption and Maintenance Act, whether aggrieved person can claim maintenance again under the Domestic Violence Act. And in 2016, in Kiran Patidar versus Sanjay Patidar case, Apex Court of India has clarified the issue that yes, multiple maintenance can be claimed by aggrieved person. Even though maintenance is granted under any other law, it can be granted even under Domestic Violence Act. But the duty of magistrate is to adjust the amount which has been granted by other courts. So he has to take into consideration the amount which has been granted even by other courts while granting maintenance under other proceedings. Friends, another issue is there, which is if the husband is died, then whether wife can claim maintenance against relatives of the husband or in-laws. Judgment is passed by Apex Court last year in Ajay Kumar versus Lata case. And in this case, Apex Court of India clarified that brother-in-law is liable to pay maintenance to widow and even a child of his brother from joint family earning. So maintenance from relatives can be claimed by widow from the joint family earning is a law evolved by Apex Court in Ajay Kumar versus Lata case last year in 2019. Another important issue is there, that is whether aggrieved person includes divorcee. Again, judgment is there, that is Juveria Patni versus Atif of 2014 given by Apex Court, wherein Apex Court has clarified that a decree of divorce will not absolve the liability of husband to pay maintenance. And under even Domestic Violence Act, maintenance can be claimed. Daniel Latifi is also there in relation to Muslim personal law, wherein Apex Court has clarified that not till Iddat period, but even beyond the Iddat period also, she is entitled to claim maintenance, and that is till her remarriage. Now, the issue is, magistrate is entitled to grant maintenance under this particular law. Does it mean then he can grant maintenance as per his own whim and fancies? He can grant maintenance as per his own assumption. That is not the case. Even to some sort, the jurisdiction of magistrate is controlled and supervised by superior courts. One judgment of Bombay High Court is there of 2018, that is Prakash versus Amrapali. In the judgment, Bombay High Court held that if maintenance is to be granted by magistrate, then magistrate shall take into consideration the capacity of the husband as well as the need of wife. He should balance both these important aspects, and he should not grant maintenance on his own assumption and surmises. Very importantly, another important issue is there, that is whether male person can claim maintenance, whether male person can claim relief under the provisions of this act. The answer is yes, even male person can also claim relief under this act, but to limited extent. And the extent is only section 21 of the Act of 2005, that is visitation rights. So if application is filed by wife under section 12 of the Act, and if that application is pending, and if the custody of the child is with wife, then husband can file application under section 21 of the Act, and he can claim visitation rights of that particular child. And if the magistrate came to know that in the interest of child it is to be granted, then he may grant that particular application, and husband may be permitted to meet that particular child. After this, another important aspect is there, that is usually at the time of interim application hearing of maintenance, monthly maintenance is passed, lump sum amount is not granted. But again, Madras High Court has clarified in Jagdesan versus State of Tamil Nadu case of 2016 that all order that can be passed by magistrate under section 12 can be passed under section 23 of the Act also. So not only Monthly maintenance can be granted under section 23 of the Act while granting interim maintenance, but even lump sum amount can also be granted under section 23 of the Act is a law laid down by Madras High Court. And so far as today's discussion is concerned, last important aspect is there, that is, if order of maintenance is passed by magistrate and if that order is not obeyed, if it is violated by respondent, then what remedy is available to aggrieved person? Friends, there are two inconsistent views given by Bombay High Court. First view is in relation to section 28 clause 1 and second view is in relation to section 28 clause 2. First view was given by Justice Tehliani and second view was given by Justice Roshan Dalvi. Coming to first aspect, maintenance amount is not paid, how it is to be recovered? The first judgment is Sachin Bodle versus Sushma case of 2014, wherein Justice Tehliani held that if maintenance is not paid by respondent, then it can be recovered as per the procedure which are laid down in CRPC. And in CRPC, the procedure is laid down in section 125 clause 3 of the code. Recovery of maintenance, levy of fine, that is provided in CRPC. And according to Bombay High Court, in Sachin Bodle case, when section 28 clause 1 deals with the procedure of CRPC, and if CRPC has laid down procedure for recovery of the maintenance under section 125 clause 3 of the Act, 3 of the code, then aggrieved person has to file application under section 125 clause 3 of the code for recovery of the amount. But another view has been taken by Bombay High Court in Sagar Shende versus Naina Shende case of 2013, wherein Justice Roshan Dalvi has clarified the law, wherein she said that if maintenance is not paid by respondent, applicant can file application for issuance of non-bailable warrant against the respondent, and if the court is satisfied that no maintenance is paid by respondent, the magistrate can issue NBW against the respondent. And the justification given by Bombay High Court is that according to section 28 clause 2, magistrate can lay down his own procedure while dealing with the application under section 12 and section 23 of the Act. And as magistrate has a power which are inherent, which are extraordinary, magistrate can use that power to achieve the end of justice, and even issuance of non-bailable warrant against respondent is justiciable under section 28 clause 2 of the Act. So there are two views. First is recovery of maintenance under section 125(3) of CRPC, and second is filing of application for issuance of NBW. Even though there are two modes for recovery of the maintenance, magistrate may adopt any of that particular mode with a view to recover the amount which is pending against the respondent. This practice and procedure at present has been followed in trial courts while dealing with the application filed under section 12 of the Act, and even the magistrate has also laid down his own procedure under section 28 clause 2 of the Act. Apex court as well as trial court as well as even the high courts in India have also tried to settle the law, to evolve the law, to develop the law in relation to the Act of 2005. And now there are so many areas in relation to this particular Act of 2005, wherein unwillingness of legislature has been substituted by willingness of judiciary. I am very much thankful to organizers for giving me an opportunity to discuss practical aspects in relation to the Act of 2005. Thank you very much.
Thank you, sir. Thank you very much. There are a few questions. Advocate Hani will take all questions. Hani, please.
Sir, I cannot see the questions and on the Zoom app. It could be in the YouTube app. Yeah. I got the question one from Anil Pratap saying, can
Yeah, you
petitioner
start with.
made party? Yes. Sir, can petitioner made party to employer for recovery of maintenance?
No, employer cannot be made party. Court can direct employer so far as recovery is concerned.
Sir, there is one question from Vinay Bokre. After compromise, section 498 can be continued.
After compromise?
Can section 498 be continued?
After compromise of matter under section under 2005 Act.
This question was asked by Bhushan Borade on YouTube.
The law is that, see, when the matter is settled, all the proceedings are settled. But if only the matter of 2005 Act is settled, and if she want to continue with 498A, it is her discretion. It is her liberty. She cannot be asked to even withdraw the complaint which was filed by her under section 498 of the IPC.
Another question is there by Vijay Oak, sir. If respondent accused is acquitted in section 498A for lack of evidence, does it have any impact on proceeding under PWDV Act 2005?
No, because so far as criminal law is concerned, the acquittal is based as the case is not proved beyond reasonable doubt. That particular rule is not applicable to Domestic Violence Act, because in Domestic Violence Act, the rule is based on preponderance of probabilities. So even though acquittal is there under section 498A, it will not absolve the liability of husband under the Act of 2005.
Okay, sir. There is one more question. Whether the respondent can file discharge application in Domestic Violence Act, and at which stage he can file application?
Yeah, when application is filed under section 12 of the Act, and when notice is issued by magistrate under section 13 of the Act, and when respondent has appeared before the court, and if he is of the opinion that whatever allegations are made against him are baseless, then he is entitled to file application for discharge before the court, magistrate court itself. Or he may go in even a session court against the issuance of process by filing appeal under section 29 of the Act. That remedy is also available to him.
Okay, sir. Question is from Mithun Banswade, my friend. The law of domestic violence balanced in total favor of female needs to revisit for gender neutrality in today's changing society. Please throw some light on it.
See, basically this law has been enacted with a view to ameliorate the position of women in India by taking into consideration the mandate of Article 14, 15, Clause 3 and 21 of the Constitution, and in that form it is a protective discrimination. Very importantly, there are some cases wherein this particular legislation has been misused, but these cases are not more, they are less. We have to take into consideration the object behind passing this particular legislation. That's why, while considering giving application to the provision of this act, purposive and liberal interpretation is required. And so far as false cases are concerned, even the High Courts and Apex Court have also discouraged that. So if you came to know that the proceeding filed under this particular act is not maintainable at all, then you are having liberty to approach before the forum by challenging that particular proceeding. Only because of out of 105 cases are fall, it doesn't mean that the entire utility of this particular law has been outdated. That cannot be said.
Okay, sir. One more question from Vijay Oak, sir. What is the distinction between doctrine of arbitrariness laid down in EP Royappa case and manifest arbitrariness laid down in subsequent cases?
Manifest arbitrariness has been evolved by Apex Court in relation to a legislation, statutory provision, while protection against arbitrariness was in relation to even a delegated legislation also. It was much wider.
Okay, sir. Next question is by Advocate Akash Kundre. If wife is highly qualified but does not want to do job, can this be defense for husband to not give maintenance?
No, that is not a defense. It is because even there is a judgment of Justice Roshan Dalvi wherein she has clarified that even the wife is highly qualified, but if she is not working, then she is entitled to claim maintenance under this particular act. Even after the commission of violence or filing of the proceeding, also if she has started working, then also husband is liable to pay maintenance, and that particular maintenance can be continued.
So there is one explanation from Advocate Seema Sarnaik, madam. Actually, I'm not getting this. You can explain it. 498 has to be quashed under section 482 CRPC
482 of the
as it
CRPC.
can't. Yeah, 482 of the CRPC as it can't be withdrawn or compounded.
No, it cannot be withdrawn. At the most, if the proceeding is pending and if the charge is framed, then the proceeding is to be conducted by the magistrate, and after examination of certain witnesses, the magistrate can acquit that particular accused person. But before framing of the charge, that accused person is entitled to file application for discharge before the trial court. But if the charge is framed, then he has to face the proceeding. And if the charge is framed and if he don't want to face the proceeding, then they can move to High Court under section 482 of the CRPC, and in that case, that proceedings may be quashed there in High Court.
Okay, sir. No more questions.
Sir, I have the
Okay, thank you
question
very
in the
much.
Zoom app.
Okay.
May I?
Yes.
So the question is, if maintenance is not given and denied by a defendant, that is the husband, do the plaintiff have any relief?
If maintenance is not denied, then I have told you that there are two important reliefs which can be claimed by her. That is execution. She can file application for execution of maintenance, and magistrate can issue NBW against the respondent, or even recovery can be made under section 156 first 3 of the act. So for getting maintenance, application can be filed under section 12. Magistrate can pass order under section 23 in relation to section 20 if it is interim, and final order can be passed after hearing that particular matter under section 12. If not paid, then execution proceeding can be initiated against him. So there is no bar for claiming maintenance, and even there is no any issue in relation to recovery also, because even High Court has clarified that particular aspect also.
Okay, sir. The next question is from Advocate Praful. Whether the respondent can file discharge application in Domestic Violence Act, and at what stage he can file application?
As I told earlier that there are three ways for getting relief by respondent. First is when application is filed under section 12, and when after filing of that application, if notice is issued under section 13, respondent is entitled to file discharge application. If you don't want to file discharge application, he can challenge the issuance of process against him under section 29 of the act by filing appeal. If not, then he can move to High Court under section 482 of the CRPC for quashing of the complaint. And in Nandak Kishore Vyavare case, which is a full bench judgment of Bombay High Court, even Justice S.C. Dharmadhikari and other judges have clarified that 482 can be invoked not only by the respondent but even by the applicant also, so far as the proceeding under the Act of 2005 is concerned.
Thank you, sir. The next question is from Chaitanya. If all the proceedings settled and in 498A, complainant gives statement, then 498A, she doesn't have any complaint, then 498A continue. I
I'm
didn't
not
get
getting
you,
the question.
Chaitanya. Could you
That
please
question is not clear, sir.
reframe the question again?
Yeah.
So the next, yes, sir. The next question, whether appeal is maintainable against interim order of maintenance.
Yes, it has been clarified by Bombay High Court in 2009 itself. Abhijit Auti judgment is there. There are so many cases wherein court has clarified that every order passed by magistrate is appealable under section 29 of the Act. And even so far as interim order is concerned, there is no need to file application for claiming interim relief. When main application is filed under section 12 of the Act, on the basis of that main application also interim relief can be granted by the magistrate.
Okay, thank you. So the next question is from Advocate Akash Undre. if wife is highly qualified but doesn't want to do job,
Yes, yes,
can
yes,
this
it
be
is-
the
it is
defense
taken.
of husband?
I think I
And it
have
is-
Yes,
given
yes,
answers
yes,
for
okay.
2 times in this particular question.
Yeah, it is repeated.
yes, yes,
Okay.
yes. Okay.
Uh,
Okay, thank you very
Okay,
much.
sir.
I have
Done.
another webinar
Yes,
for
sir.
Solapur Bar Association. So I call it a day.
so just
Thank you very much for the organizers for giving me the opportunity.
just a moment, sir. There, Madhyama, are you there? Madhyama. आणि unmute कर उसको.
Yes, sir.
Unmute. मध्यमा को unmute कर.
Yes, sir. Yes. Yes, Madhyama, you can speak now.
Okay, thank you. Good afternoon, everyone. Thank you, sir, for giving me this opportunity to give vote of thanks. Today, we all were fortunate, and it was an immense pleasure to hear Advocate Rajendra Anbhule, sir, Advocate on Record, Supreme Court of India. We are glad and lucky to hear from such a great and extraordinary personality on topic domestic violence law, practice, procedure, and judicial views. Sir, I, on behalf of NLG, thank you for giving in-depth knowledge on such emerging topic like domestic violence in a very simple and extraordinary manner. Case laws which sir has referred made us easy to understand this subject. I once again thank you, sir, for sharing your precious time with all of us. Thank you so much. I would also like to thank Advocate Seema Sarnaik ma'am for her support and presence throughout these webinars. I also thank all the senior advocates for supporting these webinars by sharing their precious time. I extend special thanks to Professor Sandeep Sarbai sir for arranging these webinars for all budding lawyers and students and extending the scope of these webinars all over the Maharashtra. Thank you so much, sir. Also, thank to all the professors and attendees and viewers on YouTube for attending these webinars. Thank you all once again. I would also like to mention, sir, that students of NPT Law College has also made an attempt to showcase the TV cases and remedy available to women for this through a short film, which is available on My Legal Aid channel on YouTube by name Kaichi. I once again thank you all for joining us and attending these webinar sessions. Tomorrow at 11 a.m., Advocate Suek Shah and on RERA Act and Professor Dr. Kesar on Article 21 will be speaking at 5 p.m. Stay tuned, stay home, stay safe. Thank you.
Thank you, Madhyama. Thank you all participants.